What are you telling us to do?
My Lord, I would like to request to just take 3 minutes of your time.
I'm going to give you all the time you need to do.
Thank you.
And I'm going to keep quiet.
Thank you, my Lord. I just believe that before I start to say anything, I'd like to level the playing field a little bit. Because while you know a lot about the defendant, Standard Bank, who they are, their history, you have a certain perception and an image of them. The contrary is true about me. You have no idea who I am, where I come from, what my background is, why I'm here.
I thought I would keep quiet. I'm not interested to know who you are, where you come from. I'm just interested to know what the case is about. Where you come from has got no consequence or no sense. All what I want to know, I don't want to have those prejudices about where you come from, what has happened to you, and bring them
It's not about that.
I just want to know what your case is all about. That's all that I'm supposed to decide.
Okay. Well, then I need to state that my case is not just about me. I'm using this case just like I was a vocal activist in the 80s when my life was destroyed. I remain a vocal activist against the atrocities towards the people of South Africa, but it's shifted from a racial activism to financial activism. This is why I'm here. It's not just about myself. I'm using this case, and I've been using this case for the last 2 years to try and be heard by the justice system in South Africa, which clearly has not happened to this date, because the issue at hand has not ever been addressed by the courts. And that's why I'm here, to actually give us the opportunity, give me the opportunity, representing thousands of people, the opportunity to actually be heard and not use...
This is not a class action. You are here on your own.
Absolutely. I'm just stating some additional things so that because it's not about me.
I'm sorry. I said to you, I'm going to keep quiet. But the more you veer out and talk about other relevant stuff, I'll come in. But if you keep to your case, you can rest assured. I won't say a word.
Okay. My Lord, yesterday I walked into what felt a little bit like an ambush, but it was obviously it wasn't an ambush, but it felt like that to me as a layperson because I didn't, because I didn't understand what was going on.
But you remember when you first came in the morning?
Yes.
You wanted to withdraw the matter.
Yes.
And they would have been ambushed. And I said, no, you can't.
Well,
had I not been suspected, I would have withdrawn the matter. You would have been gone.
Yeah.
And they would come here, and the matter has been removed.
All right. So, but what happened yesterday is, and I need to reiterate that I do trust that I will get leniency for being a layperson representing myself.
I understand your case correctly. Yeah. You were before my Mr. jail.
My Lord, it's not about that.
Hold on. You were before my Mr. jail. You must tell me if I understand your case correctly. You lost. There was an application for leave to appeal. It was refused. You went to the CC. Right? And the application also was dismissed. Right? The CC, you were there on the 3rd or 30th May 2012, last year. And from there, nothing happened. You issued summons against Standard Bank. Right? Appearance defense was filed. They filed a Rule 30 notice and also an exception.
Yes.
And they afforded you the opportunity to remove the cause of complaint. You haven't done.
That's what I'm going to address now.
Just hold on. You haven't done that. That time period for you to remedy your pleadings is over. Right? So you are here now. You must tell me what you want to do.
Okay.
That's all.
This is what I want to do. I've handed over to you this morning a filing sheet and an affidavit, condonation affidavit, where I outline a number of things. I need to also stress that I worked until 2 o'clock this morning. I don't understand this. This is not within my realm to understand court rules and to be able to pull them out of a hat, to use them in my defense. I've had to call lawyers and advocates that don't know me to try and get as much advice as a layperson as I can.
Well,
this is the best I could do overnight.
No, your lack of understanding is reflected in your papers.
Okay, so I'd expect the court to grant me, I've done the best I can to present my case. Yes, there were oversights. Yes, there were mistakes. I want to remedy and fix those mistakes so we can proceed and actually let the matter be heard and not let the hurdles and the rules get in the way so we never ever get to the matter. I'm going to present this, what I've now put together. If I may read this, because otherwise I'm going to keep tying myself up.
Let me see. No, you can't read it. Let me see. Let me try and understand what you want.
Yes.
And you must tell me if this is exactly what you want. You have now discovered that your papers are not in order.
Yes.
Right?
Yes.
You were unaware that they were not in order.
Correct.
You were unaware that when you were sent the notice, you had to rectify your papers.
Correct.
Right? Now you want an opportunity to rectify your papers.
Correct. That's as simple as that, yeah.
Exactly. And also, I don't want you to read the papers.
Okay.
I've read your papers.
Okay.
But the issue
I'm
is
sorry to offend you, but I didn't realize you. I didn't realize you read it. So.
Well, I did. I mean, you gave me the papers.
Okay.
So the issue is now whether your explanation carries water or not. Right?
Okay.
In fact, the first point which is good in your favor, you are a lay person. You rely on other people. All what I can ask from you, why don't you instruct an attorney? Because the entire summons of yours is acceptable. And I could tell. I mean, you were writing it out of the heart.
That's where it comes from. I'm a human being, my lord. It comes from the heart. It doesn't come from the mind or any book or rules or codes. It comes from the heart.
But you see, the problem here, we don't deal with matters out of the heart.
But isn't this court of justice where we should surely justice should proceed and be higher than rules and obstructions and hurdles that prevent us from getting to justice?
It's a fact, but you will appreciate that people's heart conditions vary. So I would, if we were to go according to each and every individual's heart, and there are no rules, we can well imagine they will be hard to follow.
Right. Yeah, just the one last thing.
So your heart, your emotions should be translated into some legal principles.
My lord, I don't have the financial. The fact that I'm still here today after 2 years is a miracle. My lord, I'm sure you've looked around the courtroom. You understand how important this is to Standard Bank. They know that if I ever get to the point where they get cross-examined on this, this will expose their fraudulent activity. Look at that bench. There are 5 people from Standard Bank and one of the highest paid lawyers in South Africa, Mr. Aslam Musaji, one of the highest paid senior counsels, against me, a layperson. Clearly this indicates that this is a very serious matter to them and they cannot allow this to proceed. They have thrown everything they can to prevent me from being heard, and so far I've not been heard.
No, that's not the point. Put your ducks in a row. Once your ducks are in a row, then you can be paid.
But how do I put my ducks in a row? I can't afford lawyers and advocates.
All what they are saying is that if, say for example, I'm inclined to give an indulgence, and you go back again, you don't correct your papers in the proper way, you will be in the same position as you were. I think you want resolution of this matter. And the longer you come to court, there is a postponement, this and that and that. I mean, like today, you want an opportunity, right?
Yeah.
And then it goes with a cost order, like as you correctly say, there are a lot of lawyers around. You pay those costs. You can well imagine. So,
Well, that is why I humbly ask that costs are reserved until this matter gets heard in these papers.
I've heard you for 2 days. It's 2 days. If I want to give you an opportunity, pay the cost. You've been with me for 2 days in all fairness. You are my guest. Or I'm your guest. You feed me for 2 days.
But surely this is a people's court, my lord. I appreciate your...
It's not a people's court.
So what are the courts about? The courts are there for justice, to bring justice to the people.
The courts are there for you.
The courts are there, and I'm a people, and I appreciate that I'm your guest, and
you should consider yourself very lucky that I'm giving you a hearing.
Thank you, Mom.
In all fairness, some would not have given you a hearing. I have taken the liberty to read all the big as they are, and at this now, you can confirm them up to speed with your file.
Thank you, Marlon. So, nothing else for me to say, or is there anything you need to ask me?
I've got my sympathies for you, but perhaps these sympathies are misplaced. It's placed in the sense that if you bring an action that is just limping from the start.
Well, what I've managed to do yesterday is at least make contact with some advocates who have offered help, which will benefit me in future action.
But for as long as these advocates who are offering help are behind the scenes, it will not be reflected. We must blow their cover. They must come here. They must ask for a postponement. They must put your pleadings in order. And if they are going to give you telephonic advice and hope that you go back and do the right thing, then it's no, unfortunately.
So, can I just understand one thing? How far is the leniency of the court go with a layperson? Because I don't quite understand it. It seems that the Constitution allows me to be heard and not be obstructed through financial limitations. That's my rights. But at the same time, there seem to be certain limits where, you know, the courts and the judges eventually decide, okay, I've heard enough. This guy is just talking rubbish. I don't believe anything.
Well, you say when you appeared before Mamsela jail, when you went up to the Concord,
Yes.
they said we had enough. You understand? I said, no. They literally chased you out of court. I said, no.
Yeah, but the matter wasn't heard, my lord. The matter wasn't heard.
You asked for leave to be heard. They said there's no point in hearing this. It's a dead matter. That's why they said we've had enough. Please go. It's not me. It's Branton there who says. And who am I? 12 judges sitting alone to say they are wrong. Do you understand? They look at your papers and said, it's just a sheer waste of time. Out.
Yeah, see, unfortunately, I from what I do, I have an international reputation of credibility. Do you really believe I would be here wasting 2 years of my life, going into financial ruin, going up against the biggest law firms in the world, if I didn't absolutely believe that I was right? And all I wanted was the right to be heard, which I have been denied until now. I have much better things to do. I have books to write and research to do, which is my speciality.
Today you're getting a hearing. If you have been denied a hearing before, today when you leave this court, you would have had the full benefit of a full hearing.
Not really, my lord. The subject, our main contention, the subject of securitization has never been heard. They have never been cross-examined about it.
Wait. What you are here today, those are the preliminary steps to the main hearing. So I cannot just take the subject matter and bring it forward before they could even file the defense, before they could even be satisfied that the papers are in order. So that is the point that I've taken. And that is the point that you seem to have acknowledged, that you need some time to have the papers correct. And you said the delay that you have is only 15 days. Is that not what you said?
Yes.
So I like your papers.
Thank you, my lord.
Simon, can I just be upfront?
I would appreciate that.
There's a layperson who firmly believe that there has been an injustice in his cause. He wants to have his case adjudicated upon. Unfortunately for him, he has gone about it wrong. He has sought to exclude the lawyers from his case. There must be a reason why, either it's financial or something else. But he thought he could do it on his own. I have gone through all those 12 or 13 exceptions. They are all good. His pleadings are good. You've given him an opportunity to remove the process. He seemed not to have understood what was expected of him. And I think in all fairness, late as it is, it will be fair that I afford him this opportunity. correct his papers, have his case adjudicated. I mean, he's arguing from the heart. You and I are talking from the mind. He's too intimately involved in it. He feels and thinks, rightly so, that justice has been done. I mean, if we are to say, now your papers are not in order, all the exceptions are upheld, go home. I don't think when he walks out of this court building, he will be content that justice has been done. I would not be comfortable shutting the door right on his face. It's actually, I can't sleep at night if I were to do that. He's a layperson. If he was a lawyer, I would say, stuff it up. You ought to have read the books. I mean, we've quoted Rule 1810, 18.4. I think to him it's something else. We want to know. I mean, some lawyers don't even know. So, I know the bank wants to have this case funded. The bank has not few interest against it. I think my take is we afford him an opportunity to put his house in order. And once the house is in order, if the house falls apart or falls on his head, so be it. At least he would know that this court did give him the opportunity.
And Lord, could I respond to it in that way, that we appreciate your Lordship's sentiment and we appreciate the attention that you're giving to it and that you take it seriously. What we may say, my Lord, in response to your Lordship is this. It seems that in regard to the exception, there is no real issue left in so far as it is concerned for this reason. The exception is conceded by him to be good and his pleadings are irregular. The normal order that a court issues under those circumstances is to give him a limited period, 15 days is not unreasonable. The normal order that would follow if the exception were upheld and the pleadings were regarded as irregular, he would have that opportunity. This is not any ambush on our side. We tried to understand what it is he wants yesterday. We gave him an opportunity to file an affidavit if that's what he wanted. We are not in the process of trying to obstruct Mr. Tellinger this motion week. That's not what this is about. What it is are processes which he launched, not us. He makes it look like a harassment by us. It's not. We have also rights. We may be a financial institution, but we also have rights. If somebody accuses us of doing something wrong in a summons, that summons must conform with the rules in a way that we can understand it to respond. So on the exception, it seems as though there's really no debate. The proper order on what he has submitted to you is your Lordship should issue an order that the pleadings as they stand are irregular, the pleadings as they stand are exceptional, and he should quite rightly be afforded a period of 15 days to make whatever amendments he likes. So, and costs obviously would follow from that, so there's no real issue about that. It seems as though we are both in agreement.
Well, that's what I thought.
Yeah, we have no difficulty with that, my Lord. But let us not forget that there's another application which needs to be dealt with, and that is a rescission application which he has launched. Now, in that rescission application, and I don't want to pick at him about rules, but if we get to the substance of what he's saying, he says he launched a rescission application. We filed an answering affidavit. He did not file a reply. If I understood him yesterday, and if I look at his affidavit today, what he's saying is he wants to say something further within that rescission. But so there are two aspects that need to be dealt with. The one is there some replying affidavit that's to come, and should your Lordship grant him a right to file a reply? And second, what has happened to the time and should your Lordship grant him condemnation? But more importantly than that, if we want to talk substance and not technical issues, more importantly the question is, What is it that he wants to add to this debate by reference to this affidavit, which will make something more meaningful out of the matter? If your lordship wants to look at the substance of it, and the answer to that is nothing. There is nothing to be added by this affidavit. What we know from this affidavit is that there is, he says, a whistleblower who is valueless to your lordship. If you look at, and I'm taking him on his own terms. He wants to be taken on his terms, well, take him on his terms. What he says he has is very little. In fact, he has nothing. And if you look at how carefully this has been phrased in terms of the whistleblower, you'll see you really have nothing. In paragraph 15.1 of his affidavit on page 8, he says, this is all we have. I have obtained information from a whistleblower from the defendant that is willing and able to present such proof. Oh, what proof? However, due to the process under the Whistleblower Act, I am unable to fully use the information until the protection under the Whistleblower Act has been concluded. Now, how does that allegation, because that's all, advance anything in any of his matters? You know, we are also litigants. And
can I just ask,
it's just nothing.
What happened to the house?
My lord, on the papers, there was a sale in execution. It's already been sold.
It's sold.
It's sold.
And who's still in the house? Is he still in the house?
No.
He never resided.
He's out of the house.
He never resided in that house.
Okay. So somebody else is in the house. Or he
I
never resided.
I don't know.
So vis-a-vis the bank, if there's any prejudice that it will suffer, insofar as the house is nothing, there is the bank.
My lord, prejudice in what sense, my lord? We're dealing with a rescission application and an application to set aside a writ. The process of execution is complete.
That's what I'm saying. That process has gone and it's done.
That's the problem with it, my lord. It's not only gone and done, it's gone to the Constitution Court and done. So if there was something to be said further, it's one thing. But I don't know what's being said. I can't respond to this because it's a nothing. There's no adding to the debate about this. Sorry.
Can I just ask you to sit down?
Sorry.
My lord, yes.
On the exception, that is on the summons.
Sorry, on the exception that what?
The summons, your summons, the damage
Yes.
summons.
Yes.
You afforded an opportunity to put your house in order.
Thank you, my lord.
Right? No, we're just talking.
Oh, right.
All right? This other process, I don't know what is intended to achieve.
Well, it's intended to
You know why
achieve.
I'm saying this? Because
I understand where you.
whatever remedy was available to you, you have got up to the last court. And the last court has said to us and to you, this is my final word on this issue. And if the Constitutional Court has spoken of this, and their word is law, and now what you are seeking us to do here, to try and circumvent that process. Can I tell you what you ought to have done and you did not do, and you will live to rule that day? You should have gone to Bloem by way of petition, and Bloemfontein decides what to do. But that time has now gone under the water.
My lord, if I may just quickly respond, you said that I've had all the opportunities to. I have not. This is why we brought this new action, because, like I said, the issue of securitization, and we mentioned it, that has never been exhausted. And they've never been cross-examined by any judge on that issue. It's a complex issue.
The issue of securitization would still be alive in the summons that you have issued against the bank. But what you are now seeking, you're seeking to bring additional evidence by way of a whistleblower. And I did tell you yesterday that you must give us some meat that deals with the case.
My Lord, this person fears for his life, I must tell you.
Now,
This person fears for his life.
What will happen if this person fears for his life and this person does not depose to an affidavit? It means, in essence, there will never be anything put before court. And still, the whole process, with respect, it's academic.
Well, I'm glad you used the word academic, because I'm here. I believe an injustice was done. I believe that the bank does not have locus standi. We have evidence to prove it. We've got letters from the bank, from the registrar of banks to support it. None of these issues have ever been dealt with and cross-examined. So
let me see if I can come to your aid. Your action, your 7.5 million case.
yes,
Right? And the rescission application, right?
yes,
They are all intended to achieve one and the same purpose. Understand?
well, it's a knock-on effect. The one will cause the other to be rescinded, because if I'm successful with the summons, then we will use that success to argue that the judgment was.
I don't understand why you just don't concentrate on what nobody can take away from you.
What is that?
Your right
Yes,
to litigate against the bank by way of summons.
that's what I thought I did, and I obviously did it incorrectly.
Because no court has said to you, go away. That is a lie,
Yeah,
and you are going to be afforded an opportunity to correct your papers so that you can possibly adjudicate that right that you have.
okay.
But
So
the other one, which you think you have,
yes,
has been taken away by judgments. So it's no longer there for you.
but
But,
okay,
this one that you have on summons,
yes,
if you are successful, it will put you back in the position you were before the judgment.
yes,
So in other words, you
Yes.
will achieve what you seek
Okay.
or what you sought to achieve then and now.
right. I think the idea behind the rescission application was to stop any further financial damage to me while we are proving, attempting to prove, fraudulent activity with the summons.
As far as the bank is concerned, once they obtain an order and the property was registered and sold to somebody else, file closed. No longer have any business to deal with you.
Yeah,
But now you've brought the bank into the picture. You want this and that.
yes.
Now the bank might walk up.
Can I ask you just one question, my Lord? What I found yesterday through some advice that I was given by some of these lawyers and advocates that I spoke to, they brought up, I think, Rule 42 or something, that if new evidence presents itself after a judgment has been passed, that new evidence can be brought. And I believe that you have the power, you have the ability to say, okay, as a judge, you have the right to say, I believe that such evidence can be presented.
Pause there. Your whistleblower
Yes.
does not want to come forward and tell us what is new that would influence me to say, this is new. Had all the courts been apprised of this new fact, the judgment would have been different. There's nothing.
Yeah, well, we found the whistleblower in the last week, my Lord. Yeah. That's when he.
But let him go and blow his whistle far away from this court.
Okay.
For now, one, you will have an opportunity to amend. You'll do a draft and sign. You'll amend. The other one is doomed.
Can I say to assist him? I think maybe 15 days. It's the job that he wants to do, and he says he's going to contact lawyers. We are happy to give him 30 days. I think in these circumstances, give him 30 days so he can go and do whatever it is that he wants to do.
Thank you, my Lord.
All right, just do the draft. Thanks.
So if we can do that draft, then my Lord, if we can mention that again.
Just interrupt me.
Is the draft going to be then in respect of the rescission that application is dismissed?
It's best. Yeah, it's best.
And then this one, the exceptions and irregular will be upheld, but he will be given 30 days to amend together with costs.
And then that whistleblower will come and you put pressure to the bank. If it's sustainable, you get your money back. Okay.
Thank you, my lord.
Thank you, my lord. We're indebted to you.
Oh.
So is that it? Okay.
No, it's not it until I said it.
Oh, sorry.
So you can go, but there will be a little paper, then I'll ask you to confirm it, and that's it.
Okay, how will I get the paper? Via...
You will get it now.
Now?
Now. You wait, you go to sign.
Okay.
It takes a while to type and whatever, but if you're around here, we'll find you.
Okay.
If you give us a number that we can contact.
Or do you, can you email it to me?
No. I think he must be here.
He must be
Okay.
here.
Please let him be here.
Yes.
Okay.
Please
All right.
be here.
Thank you, my lord.
Don't go away until I say you must go away.
All right.
I
Thank
know
you.
you're not in.
Oh, so must Mr. Simon bring it back to you?
And you'll be.
And I'll be here.
You'll be here.
Okay. All right. Thank you, my lord.
Thank you.
Are we still fighting?
We have shown him a draft order. There are a couple of odds and ends that I want to draw to your attention about, but I think he might have comment as well.
I go. Have you looked at it?
Yes.
So have you got some queries about
Just I just need an explanation from you, my lord, on
what?
just this term here.
What is that term called?
Particulars claims set aside as irregular in the respect of identified in the defendant's rule 32B.
Yeah.
Just if you could define what that means.
Let me tell you all what's going to happen is you are going to have an opportunity to put the pleadings properly.
Yes.
Yeah.
Okay.
Yeah. So it doesn't mean that
They would okay.
no,
That's
you will try and put them together.
yes, because from my perspective, I catch someone stealing from me, right? I need to.
Your perspective is not a court perspective.
I know. So I need to. Okay.
The order will be that the application for a postponement is refused, the application for rescission is dismissed. Now, if your lordship would have reference to costs on the attorney and own client scale. Now, the only justification, I'm going to leave it in your hands.
No. Party and party.
If it's party and
No,
party,
no. Mr. Tellinger, costs on attorney and client scale are heavy costs.
I know. I was going to ask you something about that,
No,
my lord.
I'm not.
We're leaving it in your hands, my lord.
No,
If you're
I'm
happy.
not.
I wanted to ask you one thing, and this is purely, I need to understand how the court sees lay people, because I don't really understand this, if I may. If I was an illiterate farm worker from Mpumalanga that found somebody doing him wrong, please indulge me on this.
I'm listening.
And a lawyer gave me advice, who couldn't assist me because I couldn't pay the lawyer, but he gave me advice and helped to draft some papers. I took the lawyer's advice. I came to the court, who I believe is the highest level of justice. I submitted my papers. I cannot write, I cannot read, but I know that somebody did me harm and they stole from me. I'm trying to tell the court my story. If I was that person, would you treat me, or would the court treat me differently to me as a layperson as well?
The court cannot answer hypothetical questions.